Hello everybody, welcome to my video blog. This blog is part of my website, and you can reach it by just typing in uslegalwriting.com and adding /blog. Since the horrific shooting in Tucson, many political commentators and politicians have been calling for a more civil tone in political debate. A useful idea, for sure. And it got me thinking about the tone that we lawyers use in legal debate. That is, the documents that we file in court to move our cases along. For the most part, I think, the written back and forth in civil litigation is pretty tame. Lawyers usually argue the facts and the law and leave the personal attacks alone. Occasionally, some of us wander off into that netherworld where questioning the motives or the character of opposing parties or counsel seems well advised. It never is. It never will help your case, and more often than not, it will hurt it. Why is it that the personal attack, the casting of an aspersion, the sly jab, is a bad idea? Well, for the best reason in the world. Judges don't like it. What they want is order, decorum, respectful conduct. They recoil from personal rancor because it disrupts the smooth flow of proceedings. It makes settlement more difficult than it needs to be, and it adds unnecessary stress for all concerned, including the judge. I know this from observing the reactions of judges in court over a period of many years, and I've also heard my friends on the bench talk about it from time to time. But on the chance that my say-so doesn't persuade you, here's what a couple of genuine legal writing heavyweights have to say on the subject. Quote, "Cultivate a tone of civility, showing that you are not blinded by passion. Don't accuse opposing counsel of chicanery or bad faith, even if there's some evidence of it. Your poker-faced public presumption must always be that an adversary has misspoken or has inadvertently erred, not that the adversary has deliberately tried to mislead the court. It's imperative. As an astute observer on the trial bench puts it, an attack on opposing counsel undercuts the persuasive force of any legal argument. The practice is uncalled for, unpleasant, and ineffective." End quote. Now, this comes from the recent book, Making Your Case, The Art of Persuading Judges, by Justice Antonin Scalia and Brian A. Garner. So the next time the devil whispers in your ear that it might be a good idea for you to accuse opposing counsel of willfully misrepresenting a fact or committing some other nefarious deed, resist. Don't do it. Just nail down your version of the facts and leave open the possibility that you're where the opponent's guilty of nothing more than a good faith mistake. When next your adversary outrageously distorts a controlling authority, like that's never happened, don't say that he misrepresents the case. Say instead that he misreads it. Follow the advice of Justice Scalia and Brian Garner. You can't go wrong there. To the question, when should you use a personal attack in legal writing? The answer is never.